The appeals are allowed. The sureties are discharged from their liability because they're on bail. Both the appellants are on bail.
My lord,
You just draw the microphone closer to you.
for the first time.
So for a fast writ appeal is concerned, my lord,
Ah,
I have served the copy. Only defect is 5D. Copy not served. I have served the copy, but receipt might have been misplaced, my lord. But I have served the copy.
already in other writ appeals.
Other writ appeals, your lordship have already issued notice and some interim orders have been passed. And those writ appeal also arising out of the same judgment, a common judgment, which Mr. Dr. Lenka has filed the writ appeal. If your lordship will fix up a date, next week, any date, so all the matter can be disposed of. Because a common judgment.
Right.
Taken up today? What?
Maybe
Maybe taken up today,
but
but
because
I
Mr. Lenka has filed the
I
appeal.
have succeeded in the writ petition. There is no interim stay of
We
the
understand
order.
there is a one
I am
problem.
yet to get an employment.
Right, it's a 7 days time only. We have waited since 2020
It's my duty,
in
man.
the appeal, and it is a writ petition of
Okay.
2015. So we fix a date in the next week because this was
Yes,
first
yes,
matter.
Yes, yes.
Yes, ma'am.
Anita Mahapatra versus State of Orissa is a fresh appeal. In those appeals which are not admitted, we are admitting those because the parties are represented by the state is there already. So the next date we take a matter because since it is from the common judgment, we'll take all the hearing together. It's all right, Mr.
Yes.
Doctor.
And so far Dr. Lenka's appeal is concerned, also hear that matter along with all these cases.
No, notice has not been issued in that, so
So
that
it is a
formality.
Formal notice
formalities
just
to be, yes.
in first item, I heard Mr. Dr. J.K. Lenka, learned counsel, appealing to the appellant. Stop. The common judgment dated 7/9/2022 has been challenged in this intercourt appeal. It has been stated to us that the challenging the said judgment, the appeals filed with the other writ petitioners have been already admitted. Stop. Having that aspect in view, we admit this appeal to be heard on merit. Since Mr. Naik, D. Naik, National Government Advocate, appears in web's notice for the opposite respondents, no formal notices called for. Let the matter be listed on 11th of July. 18th of July. Before that, 18th of July
At 2 o'clock.
at 2 p.m. 2 p.m. matters are there. 19th. Oh, that there's 17th also. 21st.
21st Friday.
24th or the some.
What about the 10th of July? But you are fixing on 10th of July. State. 10th of July. When there shall be a serious. At 2 p.m. when there shall be serious endeavor to hear the matter on appeal with
And
analogous writ appeal.
All cases are all.
So others you just passed where admission is not there, you admit in the same manner.
10th July at 2
At
p.m.
2 p.m.
2 p.m.
10th July.
private opposite parties are concerned, they can just serve us the copy because the private
That is
opposite
why.
parties are also appellant here.
And so far
In this appeal,
No, in another appeal, that is 1256,
You
that's
just
there,
point
probably
out,
serial
just
number
point
3.
out which appeal.
that orders have been.
Suchismita Mahapatra is the private opposite party in Dr. Lenka's case. She's also an appellant before your lordships in 1256/2022, probably third serial in that.
First, second,
Second.
third.
will you extend the writ appeal copy?
So that order has
We are
been passed.
admitting just Mr. Savitri Ratho and senior counsel. Who is assisting today?
Sucheta Gubansi.
Just write her name, huh? Junior.
Respondent number 4.
Uh,
Board of Secondary Education.
the same order, admit, because you are challenging also the common judgment.
It's common judgment. In all cases,
So-
common judgment.
Mr. D. Naik, learned government advocate, appears in Webb's notice for
1, 2.
response number 1 to 5, 4,
1, 2 and 5.
and no, 1 to 4, I think.
No. First one, 1, 2 and 5. 3 is Board of Secondary Education, 4 is Suchismita Mahapatra. You are having a first.
No, it is her appeal. Suchismita Mahapatra is the appellant there. Anita Mahapatra
No,
is the
no.
private
First
respondent.
item in which you
In the
receive.
first item, she is
You
the
should
respondent.
notice. She is opposite
And
party.
I understand that. I will ask Dr. Lenka to accept the notice.
And
That,
I am also an appellant in 1256.
I also accept notice over.
I am also an appellant. That appeal is also listed. That is 1256 of 2020.
no, that is we are passing order in 1 to 5, 6 only. You are accepting notice for 1, 2, 3 and 4. And Dr. Lenka, huh? This is the earlier appears in Webb's notice for the respondent number 5. All right, we check up all the matters together.
Page 2, item 4 to 12.
First one order necessary. To serve
You have
copy.
admitted.
To serve copy on Ms. Rath, who appears for opposite party number 5. That is what I was reminding.
Direct the parties to
This
exchange
is the
the
first case, the D Naik for opposite parties number 1, 2 and 3. And what is the name of your junior, Miss Rath?
Guman Singh, Miss Guman Singh.
Guman Singh.
Yes, Guman.
And that case, just as Guman Singh, these are 1, 2, 3 and 5, and Miss S. Guman Singh appears in Webb's notice for the respondent number 4. Is there any other private?
5.
Just check up.
4 is Board of Secondary Education.
Let us see.
3 is the Board of Secondary Education.
I have a wrong brief. It appeal.
Okay, maybe so. Just check.
I have a wrong, It is all right.
No,
1,
it's not all right.
1, 2 is.
Something
One of the opposite party, the Board of Secondary Education.
right.
So, Mr. Naik for 1, 2 and 5.
How is he appearing? Mr. S.S. Rao usually appears.
No, not usually. If he's not there, we cannot ask.
We'll serve a copy to.
This is sending others.
Who was appearing before the single judge? Sorry?
Mr. Biswajit Parida.
For Board of Secondary?
All right, this is 1, 2 and 5, no? The first case. Mr. Biswajit Parida,
Mr. D. Naik.
learned counsel had appeared for the opposite respondent number 3 before the learned single judge. You direct the appellant to serve a copy on him to complete the service on the respondent number 3. Just you serve a copy on the and say that his court request to accept it. So, and Mr. S. Guman Singh,
Miss.
Miss S. Guman Singh, learned counsel, has appears in Webb's notice for the respondent number 5. Copy be supplied.
4.
Exchange.
Respondent number 4.
Brief will be exchanged so that.
That's all.
Then 2. 2 is Purna Chandra Rath.
All you check up, and if you have any difficulty, come to me. No, others, whether in WA 1-260-2021, Mr. Pati is there.
Yes, Mr. Pati, I am in fact appearing. On behalf of Mr. Pati is
There
there.
also notice has to be
I'll
issued.
file my appearance memo. Mr. Pati is there.
Whether it has been admitted earlier.
No.
I think notice has been issued. Your
First
Lordship
appearance
passed
is
orders in
registered.
WP, REIT appeal number 1259 of 2022. Srimati Saspita Naik case.
No. Fine.
These also you admit the
And
same
the
way.
same date, that
Ah.
the same date, all cases were, yes. The state common order has been.
The problem is that the first order should be who is
Yes,
appearing for
yes.
whom, otherwise they will create a confusion later on.
If your lordship can pass orders in
And,
1259 of 2022, because that was the lead case where your lordship passed orders.
Who is appearing for the
I am
Vijay Kumar Porida and others? 567?
1259. Well, both. Yes, I am appearing in 1258, 1259 and 1260. Your lordship have passed order in writ appeal number 1259 of 2022.
But what the other council? This suppose I have taken the WA 1260 of 2022. There are
Yes.
three private respondents. Vijay Kumar Porida, this appears to be the writ petitioner, Onita Mahapatra,
I am appearing.
and
Yes,
Subhasis
Amit Das,
Mohanty.
I am appearing for Vijay Kumar Patel.
Your case.
I am probably in all the appeals, I am the party there.
And Onita Mahapatra is Dr. Lenka.
Yes.
Yes,
Then Mr. Das, the last
And
two
Subhasis
appeals.
Mohanty.
Last two appeals.
nobody is
That was
appearing. In fact,
Vijay Kumar Patel.
no, before the single judge also nobody is there. Copy. Yes, I did
Probably
copy input.
that
All the
candidate
appeals-
has got an alternative job, so that's why he's not.
He's not
there.
interested.
Yeah.
That is also our case.
Anyway, just we direct to serve the copy by speed post.
Yes, yes.
Let us
Oh.
see. Because it's Jagat Singhpur, hopefully by 10th it will reach there. In this case, this WA 1260, the appellant shall take steps for service of notice on the respondent number 7 by speed post by tomorrow. That's all. This will be added. Let us check everyone by
Yes,
as a
yes, yes,
peculiar
yes, yes.
cases and all.
That should not be any, yes. And an application has been filed in all these three cases to dispense with the filing of the certified copy. Your lordship,
In this case also the
Also.
same order will be there, no? This 1259, similar order. Is Vijay Kumar Porida and Onita Mahapatra and 7 by speed post. Then 1258, Manoj Kumar Poti.
First, the dispensing.
yes. Appearance of final.
Mr. Poti is for the appellant. And 1, 2, 3, 4 and 2, 3, 4. Mr. Naik. And other three the same, Vijay Kumar Porida and Onita Mahapatra, Subhasis Mohanty for speed post with AD. On that day. In the WA 1257,
I'm appearing on behalf of Mr. Durga Prashad.
you are appearing for?
Appellant.
Petitioner, my lordship.
Which one? Which one?
Lakshmi
Oh.
Prasad Mahapatra. One.
You are
one two
appearing
five
for
seven.
the
Appellant.
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 Yes, ma'am.
Oh, yes. Okay.
Durga Prashad on the senior. head.
Ms. S. Maharana. Land Council appears for the appellant. Huh? Then Mr. Naik for 1, 2, 3, 4 and 5 by registered post, huh? Like
That case you file an miss case for intervention. WA 1257. Or you have appeared.
I was with party there. Vijay Kumar
so you
Patel is
have
a party in all
Ms.
cases.
Roth,
Because I
you
am
have
the-
two cases, 1255 and 1256.
1, 2.
Right, 1256, so you have taken note, no? 1257, the same similar order. So, okay. And wherever the petition for dispensation is there, in view of the common judgment has been passed in, common judgment is challenged, the prayer for dispensation stands allowed. So 10th July.
Ma'am.
I would request as a prepare
Short note. This is
Short
very, in fact,
note,
very
because the
short
lot of
question,
matters
yes.
together,
Yes,
if there is a difference of fact, you just highlight that part, other parts will be
Uh,
common.
a concern.
Actually, there's not much.
No much difference, okay.
That
Page
is in
2,
filed by Mr. Sethi, intervention by Mr. Sethi. Not there.
page 2, item 4 to 12. Page 3, item 13 to 20.
Item 15, my lord. Can it be taken up for 1 week after?
Yes. why
Alright.
not? Because you have not filed the application for condoning the limitation as yet.
Some defect I pointed out, I will remove it.
Major defect is that there is a limitation. Your application, the appeal is barred by limitation. You have not filed the application.
I will file the limitation.
Whatever you do, the matter will be taken up on 27th. The request of Mr. N. Pandal and Council, the appellant, let the matter be listed on 27th July 2022. Taken in the meanwhile, no further accommodation for that purpose will be made by this court. Next.
Page 4, item 21 to 25.
24 matter, office pointed out limitation of 34 days. But according to there is no limitation, but I filed a condonation application.
All right. You point out when the matter will be taken up, not in the mention. Yes.
Page 5, item 26. Page 6, item 27 to 29. Page 7, item 30 to 32. Page 8, item 33 to 36. Page 9, item 37 to 42.
39, my lord. After 1 week after, my lord, file the translation copy of the annexes, OD annexes, my lord.
Translation you have not filed?
No, my lord. 1 week after.
You are Mr. Das.
Yes.
At the request of you are Mr. Sharoj Kumar Das,
My lord.
London Council, appearing for the appellant. Let the matter be listed on 27th of July 2023. Meanwhile, the vernacular text, the translation of vernacular text shall invariably be filed. No further accommodation will be made for that purpose.
Page 10, item 43 to 49.
My lords, item 46th, but that my lords have fixed today at 2 p.m. I received the rejoinder day before yesterday. I've gone through the rejoinder. There seems to be.
Please add to mention the
I'll-
because the other
my lord.
council will not be available right.
I have informed in the morning and taken his
Alright.
consent.
How much time do you require?
Last week of July, my lords.
28th July? Huh? At the request of Mr. D. Naik and Council appearing for the respondents, let the matter be listed on 20th of July 2022 in the stuff. Mr. Naik, Learned Additional Government Advocate has sought this accommodation for taking instruction on the government's making the rejoinder. So it has been also informed by Mr. Naik, Learned Additional Government Advocate, that he has informed the council for the petition.
Mr. Kanun.
Petition. Okay.
Item
Item 43, your lordship.
Ah.
Here I will appear today on behalf of respondent number 1, your lordship. I pray for 1 week after. In the meantime, I will file the objection for the limitation.
43 and 44 both are identical, my lords.
43.
43 and 44 both are identicals.
All right.
Same.
At the request of Mr. Such and Such, who has informed us that he would be appearing for the respondents.
Sole respondent.
No,
Yes.
respondent 1, I will appear for 1. And 2 and 3 are there.
Respondent, let the matter be listed on 18th, 28th July 2023. In the meanwhile, deed
My
of
lord.
power,
My lord, your lordship has fixed the date to
20th July,
my first week of August, Mr.
First one is
Because
respondent.
this
on 3rd of August.
3rd of August. Okay.
3rd of August.
43 and 44 both.
In the meanwhile, the deed of power shall invariably be filed.
Second one also respondent 1.
No,
So,
there are,
No,
I
there
will
are two.
appear 307 of 23. In WA 307 of 23, therefore respondent number 1. Only
only
that
respondent number 1.
I'm asking, you are saying no, I'm for respondent number 1. I'm asking, are you for respondent 1? You are saying no, I'm for respondent number 1. And 44?
No, 44,
You're saying yes, 44 also you are appearing.
no, only 43.
43, 44.
44 is saying no.
No, 44 you are appearing.
No, 43. Your Lordship.
Then why
Only
did-
43.
Then why did you mention
You said
44?
the other matter also similar, I am appearing.
No.
No, no,
My
other
lord,
matter is
here,
similar, 43 and
No, but
No,
he
he
is
is
not
not
appearing.
appearing.
he is
All
not
right.
there. In that case, there is a caveat.
No, somebody might appear,
All
so
right.
I should be
44
adjourned now.
The order
Yes,
first.
my lord. Yes, my lord.
307,
Yes, let it come, let it reach.
Ah,
Let it reach, my lord.
and on same date we are bringing this matter. We have fixed that matter on 28th of July,
Yeah,
3rd August,
third
your
August.
lordship.
3rd of August. That's
Yes,
the
ma'am.
same date.
This can be, that is what, but if your lordship wants, it may reach, I am there. If 44. But it can be
Oh,
posted to
yes,
that.
yeah,
day.
because there is some problem is there. Unsub notice issued census.
Yes, yes, that is also there.
Item 48.
All right, we'll call up this matter. Remember, 44 will be on the 3rd of August. All right.
Item 48, my lord.
My lord, interim order to continue in 43 and 44. Lordship may direct.
43 we have passed order. There we can mention. The interim 43 interim order is passed earlier shall continue till the next date. But
Yes.
44 because there is some order has to be passed.
43 also, what has
It will
happened
be
to
called.
respondent
Yes, ma'am.
3 also you have-
Item 48, my lord. 2 weeks time for filing rejoinder.
43 are due at
Item
the-
48.
Huh?
2 weeks time for filing rejoinder.
Which item?
48.
48. 48.
You are Mr. Patra?
I am the associate of Mr.
Huh?
I am the associate of Mr. Patra.
What is your name?
BN Sadangi.
BN?
Sadangi.
Oh, that's right. You are not on record. Oh, yes, you are there. Mr. B, at the request of Mr. B. Sadangi. Learned counsel appearing with the petitioner. Let the matter be listed on 4th of August 2023. Meanwhile, the petitioner may file the rejoinder if any in response to the counter affidavit filed by the opposite parties number 1 to 4. Who is appearing for the opposite
My
party?
lord, I am appearing.
Mr. D.K. Mohanty, Learned Government Advocate, appears for the opposite parties number 4 and 5. Yes.
Page 11, item 50 and 51.
Let's item 51. I pray that 1 week time may be granted for adjournment. But, Mr. Manthi is having some personal difficulties. That's why he's unavailable.
You are not here on record?
Yes, I'm there. S. Jana.
At the request of Mr. S. Jana, Learned Counsel, appearing for the petitioner. It is,
My lord, item 18.
you have missed the opportunity.
Sorry,
For
my lord.
mentioning item 80 should be present in the court in time. What is your prayer?
My lord, a removal of defect.
Item 18. What is your good name?
Smriti Ranjan Parda.
The request of Mr. Sajjan, let the matter be listed on 28th of July 2023. In the meanwhile, the appellant
Certified copy of the impugn order.
shall remove the defects as identified by the registry.
I may pardon to mention.
No, item 18, this one.
Yes, sir.
Are you there on record?
Yes,
You are not on record.
On behalf of Bharat Chandra.
All right, appear on instruction of Mr. B.C. Panda, Land Counsel for the appellant. All right.
I will pardon to make a mention. Because one matrimonial appeal was disposed of by this particular bench on 17th of April. It needs modification because there are certain criminal cases which has been pending. Both parties have agreed for disposal of all the same. Since I have already prepared to pay that amount, it can be go to a logical end so that it can be disposed of. I pray for modification of order.
No, we cannot direct for the bring an end to any party. They bring the end to the criminal. Because if you are agreed, you go and file there according to the agreement.
What I pray, I need only 1 month extension of time and for modification of that order. So far as pending cases are concerned, because parties have agreed for disposal of all
That
these.
time also we refused to grant that prayer because we cannot direct any persons to withdraw the criminal prosecution. It is they will go to that court and file an application either for compounding or by way of recording the statement. How a court can direct that you just bring an end to the this cannot be done.
I pray extension of time may kindly be given.
Already extension for that you mentioned, and for extension you must file an application
I've
also.
already filed. That is
Already.
IA number
Just
8
list it.
Minors, I have filed a writ petition challenging rule 4 of rule 22, and similar cases have been filed and fixed on 10th 11th 2023. I pray that.
Already 10-7. List the matter, huh, with the batch matter.
Well, eviction matter, my lord. I'll take up tomorrow, my lord. Eviction matter.
Public interest litigation.
PL.
Public interest litigation.
My lord. PL matter.
It will be taken up.
You want eviction or eviction has been directed?
You want eviction.
My lord.
What is the hurry?
So they will take up according to, just file the memo. Why tomorrow? You are not stalling the eviction. You want the eviction. All right. So there is no urgency. File the memo.
My lord, habeas corpus matter, my lord, I'll take note tomorrow.
And permission matter is not Lordship's board, that is WPCRL 12 of.
Yes. Mr. Swai is not here.
No, yes.
None appears when the matter
Defects.
when the matter is taken up. From the registry's note, it appears that the defects as identified have not been removed as yet. Let the matter be listed on 28th of July 2022. Meanwhile, the defects shall be removed. No further accommodation for that purpose will be provided by us. Next.
Item 5.
May I please, your lordship?
Yes.
My lord, this is a PIL matter. The petitioners have read in this application to evade the encroachers who are occupying the government lands, my lord.
You are Mr. Naik.
My lord, I am Karunakar Naik, my lord. My lord, the petitioners have ventilated their grievance before the collector. That is,
Regulation was made pursuant to the rise in the tribunal upheld by this honorable court and finally by the Supreme Court. Thereafter, my lord, regulation order was issued. We came back to this honorable court saying that kindly formulate a cadre scheme. And cadre was formed, my lord, for 14th February 2023, my lord.
Yes.
Rule 5 says the cadre of the service shall be devoid of any further recruitment, promotion, and confirmation in the post. How can you deny promotion when, my lord, promotion is available in all service in the state, be it district cadre, heads of department cadre, and secretariat? And based on the direction of Supreme Court said at least 2 promotional avenues must be there.
It is not a law decided. Supreme Court says that should be done.
Yes.
It is a 2005 decision you are referring to.
1988 Supreme Court.
Huh?
1988 Supreme Court.
Latest decision.
That has been followed in 2005.
2005 is more eloquent order. You are Mr. Tripathi.
Madam.
Heard Mr. B.S. Tripathi, counsel appearing for the petitioner by means of this writ petition. The Rule 5 of the Orissa Data Entry Operators within bracket Commercial Tax and Goods and Services Tax Organization Service Condition Rules 2020-23 has been challenged on the ground that further recruitment, further appointment or promotion has been totally closed by this rule. Stop. Admit. Issue notice since Mr. M.K. Kantial and additional government advocate appears in web's notice for
appointment 1 and 2.
How all the opposite parties, notice for the opposite parties, no formal notices called for. Do you require any additional copy?
1 copy.
Stop. Mr. Tripathi and council should supply 1 additional copy of the writ petition by tomorrow to Mr. Kantial and additional government advocate. Notice is made returnable on 4th of August 2023.
Item 8.
But you carefully check up. The Supreme Court decision is not a mandate, it is not a law under Article 141.
No, that's correct, my lord. But the thing is that
your argument will be on the point of legitimate expectation.
No, even my lord, Article 14, my lord, I know my limitation.
How Article 14 will be attracted there?
My lord, when, my lord, in my service, in my district cadre, all promotions, all are been promoted.
These are regarding the other post.
In same cadre, my lord, in the same cadre. Group C post, my lord.
No, this is not in the same post. This Article 14 will be difficult task. You have to build up your argument on the legitimate expectation.
I'll show you, Lordship. I'll
All
show you,
right.
Lordship.
Item 8.
Lordship, item number 13, humbly pray for some time to remove the defects.
You are Mr.
Lordship, on behalf of Mr. D. Tripathi,
Your name, please.
Tej Kumar, T. Kumar.
Mr. T. Kamal and Council appearing on instruction of Mr. Subhasis Talapatra and Council with the appellant. Let the matter be, how many days do you require
Lordship, 2 weeks time.
for removing the defects?
Your Lordship.
All right, let the matter be listed on 28th of July 2023. Meanwhile, the defects as indicated by the registry shall be removed. No further accommodation for the same purpose will be provided by this court. No further accommodation will be made unless 28th July is the date to remove all the defects.
Obliged.
Item 14.
Require some time to remove the defects, my lord. I pray at least 2 weeks time may be allowed.
You are Mr. Mishra.
Yes, ma'am.
Yes.
At the request of Mr. Sajjan, sir. So we are fixing the date of 28th of July. All right.
Another 2 weeks. Another 2 weeks time maybe.
All right, the 7th of August. In the meanwhile, they defect the same order, just change the name. All right.
Item 16.
So 16, my lord. The noting is there, my lord. I have already saw the copy on last day. 5/4/23, my lord. I have already removed the request.
Yes.
And there is a delay condition petition is there, my lord. Due to property, I could not be prepare this appeal within the time, my lord. And I pray for one week after be taken now for hearing.
You have not filed the application for delay?
Condition of delay is there, my lord.
Go item.
59 days delay, my lord, due to property, my lord.
No, it is 60 days delay according to a calculation of the stamp reporter.
Yes, yes, ma'am.
Already.
15 adjourned.
But Mr. You are Mr. A.K.
A.K. Naik, Arun Kumar Naik.
A.K. Naik and counsel appearing for the applicant. It is in IA number 2724. It is an application for the condemning the delay of 60 days according to the stamp report in filing the appeal, intercourt appeal challenging the order dated 18/5/2020 delivered in WPC OAC within first brigade 135 of 2019 by the London single judge. Issue notice as to why the aforementioned delay shall not be condoned or any other order or orders should not be passed having regard to the circumstances of the case. Notice is made returnable on 11th of August. No, 10th of August 2023. Steps for service of notice on the. No, since who is appearing? Since Mr.
I am appealing.
Sorry, not
No,
since
no,
Mr.
private.
M.K. Kuntia, Land Council appears in web's notice for the opposite parties, no formal notice is called for. Should I condone the delay?
Yes, ma'am.
This could out, right? This part, this is an application for such and such, you keep that. Headmaster is a government school, the public servant.
You can apply already.
My lord, 4 extra copy I have already served, madam.
That's all right.
Government school and
Just up to this, no, this issue notice is called out. Mr. M.K. Kuntia, an additional government advocate appearing for the opposite parties. Has appeared and fairly submitted. The opposite parties will not oppose the prayer for termination of delay. So having perused the causes assigned in the application and also taking note of the concession given by Mr. Kuntia, an additional government advocate. We condone the delay. So in the result, this application stands allowed and disposed of. So are you prepared today for admission hearing?
One week after, my lord.
1 week after. The appeal list the in view of the order passed today in I number such and such, list the appeal on such and such date. 10th of August or July.
July.
It should be July. It is admission matter.
No, month of July. Ma'am.
10th July.
In July.
Huh?
Yes, ma'am.
No, you said admission matter, 10th July. What are you suggesting?
Your lordship, fix a date, man.
10th July. 5-6 days after.
Item 17.
May I please lordship, my lord. On behalf of Mr. Chiranjay Mahanti, my lord. Due to his illness, my lord, he could not able to file the limitation period, my lord. So give me
What is
one
your
day.
name?
My name is Jayanta Kumar Padi.
You are not there?
No,
At the request of Mr. Jayanta,
Padi, Jayanta Kumar Padi, JK Padi.
Mr. J.K. Pari, London Council appearing on instruction of Mr.
Chiranjay.
Chiranjay Mahanti. Let the matter be listed on 28th of July,
Bless
2023. So meanwhile, the necessary steps is required in respect to the condonation of delay shall be taken. No further accommodation will be made by this court for the same purpose.
Oh, bless
Next.
Item 19.
18. Item 18.
19, your lordship wanted us, may I draw your lordship's attention to annexure 3 at page 94.
Condemnation of delays.
The order passed in 6/8 of 2000. Lordship, what is the page 94?
How many days? Did?
Well, this order has been passed by modifying the order passed in another WPC, my lord.
Yes.
And your lordship wanted to know whether that order has been challenged by us or not. Well, I just got the information that we have challenged it in another writ appeal. So both this matter may be
Can you give the WA number?
WA number 929 of 2023.
929. 2023.
2023, my lord. 929 of 2023. In that case also, my lord, it has not been listed for,
Admission.
it has not been listed yet.
So we direct this matter be listed on tomorrow. Both the matters will come day after tomorrow, na? 7th.
Well, at 7th, I am on
Oh,
leave.
you have a difficulty.
7th and
11th of
19th,
July,
my-
all right, 11th of July.
Yes.
It has been stated.
Short issue to be decided, your lordship.
By S. Patnaik and Council appealing with the appellant that the judgment relying on which the impugned order dated 16/12/2022 is delivered in WPC number WPC OAC number 0608 of 2019 has been allowed. The judgment, the said judgment has been challenged in WA number 929 of 2023. List is directed to list that list WA to 929 of 2023 along with this appeal on 11/7/2023 for consideration. You are appearing for whom?
I am appearing for a respondent. Private.
Yes,
Respondent one, man.
Mr. G. S. Sethi, Learned Counsel has appeared for the respondent.
Giving notice, I think.
If you what?
On information.
Well,
that
there
the
is
state
part-
has- The state has filed the appeal against the said order. So. All right.
My lord, in the 28968 matter, my lord, it was disposed of at the time of admission. So we have had not the opportunity to file any counter.
On that day.
So if your lordship will direct us to file a counter, then I might
No,
require.
we are not at this stage. Let it be listed together. And then you have to file an application Because you have not filed, you have to state that we are not given these opportunities, and though
We
it
have
is a
stated-
ground, it is a ground, but you have to seek leave from this court, because this is not the state when we can allow you automatically to file the counter affidavit. 2-page application you file, they give us later so that you can file the counter affidavit now.
It is their appeal.
In read, we have not filed the count.
Counter affidavit in the disposed of case, single matter, single judgment.
You have not filed the counter affidavit because in the admission stage that was disposed
There's
of,
no,
right?
there's no occasion for us to file.
So we are not holding this proceeding for this writ petitions, this is a writ appeal. There is no provision in the writ appeal
For
that you
allowance,
can
yes,
file.
for
So
allowance.
we are asking you, file an application seeking leave, that this was the situation, you could not file the counter affidavit. Please allow us to file the counter affidavit. That leave you must seek from this court.
So next date I'll do that.
That is what.
Have you not mentioned the grounds in your writ appeal? Have you not mentioned those grounds in your writ appeal, which you could not take in the counter affidavit? Because writ appeal is by you, I think, or am I mistaken?
No. Both the writ appeals are
By the state, okay.
Call the next item.
Item 20.
My lord, my writ application was dismissed. The petition was dated on 19th of August 22. The matter came to be listed on 25th of January 2023, directing me where the registry placed the noting that I am to take the fresh notice against the private respondent. But my writ application was dismissed on the ground that the writ petition doesn't survive as the writ petition is dead. This is the only thing, and there is a delay, my lord, because of the legal heirs couldn't come to me to file the writ appeal, and I calculated it to 59 days. The registry says it is 60 days.
All right, first we can issue the limitation notice, then we'll decide. Right?
My lord. My lord, the only problem will be, my lord, the eviction. In the writ application there was a stay order of status quo. That lapsed because of the dismissal of the writ petition.
No, whether there is any action for eviction has been taken in the meantime.
Yes, the Tahsildar has taken action steps to consequent upon dismissal of the writ petition. The Tahsildar has taken steps to revert my land to the opposite party.
All right. But why you are then delayed?
Delayed, my lord, they couldn't know it, my lord. I sent the communication to them, but since they are staying outside, they couldn't come to me. And I could have been allowed to substitute the legal heirs. The matter would have been sufficient.
File an IA for stay?
Yes. That is at.
No, the cause list does not reflect because I think it's come off orders.
3 applications are there. 2145 is the first stage. Third, Mr. Digambo Mishra. Third counsel appearing for the applicant. There is an application for confirmation of delay. Of 60 days as per the stamp report. In filing the appeal challenging the order dated 25/1/2023 delivered in WPC number 457 of 2013. Issue notice as to why such and such. Notice is made returnable on 24th of July. 24th of July 2023. Who is appearing for the state in this matter?
Government Council AGA will be appearing.
Who is appearing? You are appearing? Miss S. Patnaik,
Item 20.
additional government advocate appears in notice for opposite part,
Copy not served.
respondents number 8,
Served.
8, 9 and 10. Stop. One additional copy of no. I think you have copy.
I'll find out my close. They say they have served copy, but our
One copy of this
voting says it is not served.
Yes, I already sought, my lord.
Copy of impure order not filed.
Lost it. One copy is
Oh.
served.
I'm sorry, I'm sorry.
No, receipt not filed.
Additional copy.
Yes, yes.
Receipt not filed.
Served on Mrs. Patnaik and government advocate within 2 days. They report these applicants shall take steps for service of notice on the opposite party's number 1 to 6.
1 to 6.
Certified copy. You have not also filed the certified copy.
Certified copy has not yet been granted, my lord. I have filed an exemption application also.
All right. All right. The steps by registered post with AD within 3 days from today. You file without fail, otherwise we have, yeah, just as posted a short date.
Yes.
Because
from the registry, I will obtain it.
Download, can I pray, my lord? I'll request him, let him serve a copy on me personally, my lords, otherwise.
Have you given a downloaded copy of the order?
Already passed the
Yes.
order.
Oh, oblige, my lord, oblige.
But one thing we are requesting, you don't take any action before the next date. Tell your officers not to take any action.
Give status quo.
No, we will not grant status quo because this is a dispute between the private parties. Unless we hear them,
All right.
it will not be proper.
They have not appeared, my lord, in the writ petition itself. I was directed
All
to
right,
take notice.
but you
Yes.
try to serve the copy, then we can take a decision.
My lord.
All
So
right.
they are not appeared in the single.
Next date is the lordship is.
My friend can intimate the authorities, my lord, so that they cannot take any action.
That is already you have requested
My
without
lord,
being
I know.
asked.
My
All
lord, my
right.
lord.
In I number 3811. Heard such and such, huh? This is an application for dispensing the certified copy of the impugned order in filing the appeal. Stop. A copy of the order has been filed. Downloading from the High Court of Orissa's High Court of Orissa website. We dispense the filing of the certified copy for the time being, but the appellant shall file the certified copy
After.
as and when the certified copy is received from the High Court. From this High Court. Stop. Accordingly, this application stands disposed of. All right.
Your lordship is fixing this to, your lordship is fixing this to date
24th of July.
24th of July.
24 July.
Suppose you will not buy the step post, it will go. Yes, next.
21.
May it please, Your Honor. In the case, the Union of India challenged the order of the Honorable Single Judge under Annexure 6. The single judge has passed the order. What happened, my lord, because I am arguing before single judge. When we are arguing, we are adjudicating the matter, the CBI started inquiry. The fraud of a postmaster is fraud of 9 to some odd. Now it is increasing and the investigation going on. In the meanwhile, the Honorable Single Judge passed an order. So taking into all consideration, we have admitted we have delay of filing this writ appeal for 200 days, my lord. That may be condoned, my lord, and lordship may issue notice. Because the investigation is open now, the CBI is investigating the issue. The 9 crore some odd has been found out as a fraud, and he is keeping the amount in different relations name. All these things it was also found out by the department authorities. So after final investigation of the CBI, everything going to come to the knowledge of the department.
No, what is how you are affected? They have
Because my
copy
lord,
of paragraph 5 of this order, impugned.
my lord, my lord, what happened? They have
Come to the paragraph 5. Mr.
Yes, my
Parikh,
lord.
first.
Honorable Single Judge has passed an order.
You read the paragraph 5.
Yes. Three financial quarters have elapsed since issue of the impugned letter. Concerned post office is directed to disburse the proceeds of the aforesaid MIS account to the petition expired on 31st October 2020.
Yes.
Who is them? The relation of this petition of which accused do have deposited the amount in the same amount, and by the direction of the court, they are unto dispose this same.
Why not? Why not?
Well, because it is a fraud account. What corruption has made in the during his service, and he has diverted the amount to different names. This amount, MIS amount is involved with this. So once a amount has been committed fraud and deputed another
The
account,
party during investigation, whether you have, by taking a proper order from the court, you have freeze those accounts.
but what happened initially?
No, nothing, we will not hear you. You asked a straight answer.
Yes.
And have you shown that these accounts are opened or maintained for purpose of taking the proceeds of the crime? Have you taken a stand anywhere?
My lord, we have taken the stand in the time of inquiry that that amount has been diverted. That this much. Thereafter, the CBI has come forward and
Action you have taken. You know how to the proceeds in crime are to be handled by the investigating authorities.
we are explaining the counter, my lord. We are explaining the counter that particular account for which he has come to the High Court.
You have ever, I am talking about the action.
Action of now we're hand over to the CBI and CBI is investigating.
This is an investigation.
No, my lord, they have found this prima facie.
No, what? Try to understand me.
Again, my lord. Sorry.
That if you say this is the proceeds in crime or and this is maintaining the account, you have to immediately freeze those accounts and just take an order from the magistrate.
My lord, I'm
investigating authority doesn't have any authority to freeze, intervene with any account unless the magistrate permits you.
But the CCS rules provide the department authorities to go ahead with the inquiry and find out all these things.
Who is stopping you inquiring? Even the learned single judge has not stopped you from inquiry.
No. My lord, singular judge directed that disburse this amount. That will be prejudiced to the interest of the Union of India. Because once it was started, the whoever relations there, suppose he is keeping the name of his nephew, in the name of his wife, in the sister, daughters, everything will go even.
These are all assumptions in the eye of law. If you think seriously, these are the proceeds in crime that you have to take certain action and provided by the CRPC.
Yes.
You have not taken. You are asking the court to believe these are the proceeds in crime.
But FIR has been lost.
No,
FIR has been lost.
look at paragraph 5 of the order.
Yes. What counter we have reflected?
Not counter. After your counter, this order has been passed that if you have collected evidence during investigation against the petitioner regarding her involvement, so has her account been opened in her name?
But it is a fraud of 9 crores some odd. It is a part of his
The investigation is continuing or over?
Yes, now what happened? Peculiarity in this case is that initial department initiated a FIR has been filed. Thereafter, when they come to the High Court, we are educating the matter. CBI is enter and started investigation. So it was not brought to the notice of the Honorable Single Judge, my lord, because
and nothing would happen when you bring that particular part of the CBI has entered into the investigation. It will not change the fact of the case.
No.
I am asking some questions. You are answering something different.
But
it is a proceed in crime. You have a certain step to take, and this is you cannot do without the permission of the magistrate.
My lord, I am apologizing, my lord. Let's keep it to Monday.
CBI can ask the magistrate for freezing the account. That is what.
Yes, my lord is put this question. I heard that.
Because when the magistrate will be passing order, he or she is to satisfy him or herself that this is the proceeds in crime.
Yeah.
Because these are the individuals, they have a right of hearing. We cannot just stop their account in this fashion.
It is established in inquiry that their relations and is transfer this amount to particular one A to B and B to C or like
you have to just comply with this subsection 1 of section 167 of the CRPC. The prima facie material. You may continue with the investigation. The prima facie materials you have to place before the magistrate for such action.
In that part, I will take the instruction because after this
I
FIR,
don't understand how the instruction will improve.
No, after this FIR, they must have, suppose the police have registered the case, and they must have filed the petition before the court below, before the Lord Magistrate.
All our assumptions must have filed.
Find out.
We want that you have filed, magistrate and passed an order.
Yes.
Then all the accounts are maintained for maintaining the proceeds in crime. That's all right. Magistrate first, then we'll automatically say this order is bad. We'll quash it.
Let's keep you next week. I'll come this.
All right. Let the matter be listed on. 10th? 10th? No, is it next week? 10th is the next week. I think it should be on 17th of July. If the request of Deputy Solicitor General of India appearing for the upper.
Lakshmi Ripagnan is Babita Sahu is appearing with me.
Kavita, just with her, appearing along with Sajjan Sach.
Who like?
All right, the rest of the matters will be taken up after recess.
Lordship,
My lord, actually the name that's reflected in the cause list, that has been transferred. Now the counsel for the petitioner have told me that it's been transferred. He never did. That's why this confusion, my lords.
On consent, it was fixed, as your lordship remembers. On consent, it was fixed to today at 2 p.m. because that rule 3.3, the doctor is sitting idle.
What to do?
My lord, they filed a rejoinder. Now what I have noticed from rejoinder is that certain facts are there which were not brought to my
you have introduced certain new facts by your rejoinder.
Nothing, man. Nothing.
Huh?
No new facts. I have
Now
just replied to the counter.
cases, the matters, certain criminal matters that were there that were brought to my notice when I got instructions. It seems those are now not there. So I'll have to go through that rejoinder and make a further submission. Otherwise, my case is extremely weak. Unless I reply to the rejoinder.
Mr. Marana, one thing can we do? They just fix a short date.
My lord.
Suppose on 10th of July.
My
In the
lord.
meanwhile, they may file their
My lord.
any affidavit. Otherwise, we'll close the matter.
My lord.
And we hear the matter on that date.
My lord.
My lord.
10th July. What was the order passed earlier?
To 28th of July. It was adjourned to 28th.
So you
10th
are
of July.
preponing that date to 10th of July.
My lord.
So at the request of just 46.
46.
The earlier order will be little changed. Yeah. At the request of Mr. D. Naik, an additional government advocate appearing for the opposite parties. Let the matter be listed on 10th of July, 2023. Meanwhile, the opposite parties may file an affidavit.
My lord.
Or Mr. Naik, an additional government advocate, may take appropriate instructions.
My lord.
If any, but no further accommodation will be made on the next date. The matter will be heard on merit. Mr. Maharana, L.K. Maharana, learned counsel has appeared for the petition.
Lord, will it be at 2 p.m.? Lord?
Just 10th July, 2 p.m.
Oblast. Oblast, man. High Lord.
My lord, pardon. 29, serial number 29. Serial number 29, a specific direction was given to the state government.
All by serial.
22.
Item 22, may I play this matter may taken up tomorrow. State is the appellant. May I play this matter may be taken up tomorrow.
And, who is appearing? Are you appearing for the
State is the appellant.
The request of Mr. M.K. Khuntiyal and additional government advocate, let the matter be listed. Give the date of tomorrow. Yes.
23.
Lord, 23 also have a similar prayer. If your lordships can take it up on Tuesday, or Monday or Tuesday, any convenient subject to your lordships, because I need some preparation in the matter. All 5 writ appeals from the same order, so all the matters can be together on notice. Fresh matters.
That is the admission matter. All the matters are for admission.
Yes.
Tuesday, what is the date? Tuesday.
Monday,
11th.
Tuesday, subject to 11th or 10th, whatever subject to your lordships convenience.
When can be fixed?
Any day. I'm not saying, my lord, particular subject to your lordship's convenience. I don't.
17, 18. It will be listed on 17 because the board is congested. The request of 17. Who is assisting in Shubhankar Raut?
Your lordship.
We are Nandal and senior counsel. listed by Mr. S. Raut and counsel for the appellate. Let the matter be listed.
But
Of July forward, 17th of July. All right. You have entered the appearance
in the other
writ appeals. The other-
connected writ
Okay.
appeals, my friend is appearing.
They all are there in the same video.
next to this 1380, you are appearing.
Apart
I'm
from the
not-
first one, in all other matters, my learned friend has
I'm
been
appearing,
engaged with Mr. Venugopal.
Venugopal.
In others also named Miss Pami Ratho, senior counsel. Who is assisting you?
Mr.
V.
Venugopal.
V. Mahapatra.
V. Mahapatra. In all other matters, same order, same date.
24.
But the staff reporter pointed out that there are 34 days delay, but in fact, there is no delay because the judgment was delivered on 24/4/2023. And 30 days, there was a vacation intervening. And during vacation, it was filed.
Just give the calculation according to the staff reporter. There is a delay of 34 days.
34 days, because I'm not.
I am
seeing-
giving the date of judgment is 24/4/2023.
Yes, madam. It was to be filed, madam,
Or
24.
27/6/2023.
Yes.
All right.
Well,
Rule is that if you file on the following day of the vacation, when the vacation ends, then you'll get the benefit. Otherwise, you'll not get the benefit.
no, that's why, madam, I filed an application. I filed an
No, that
application.
is the real issue notice, but you don't say that there is no delay because vacation will be added. Vacation will not be added. Even just the opening day, you can file it, that the entire period of the vacation will be counted. Otherwise, not.
No, I have filed, madam, during the vacation.
Date says valid presentation 27/6.
27/6, how can be there during the vacation?
No, I have filed, madam, 6/7/6. That was, madam, based on the certified
Just-
copy,
just-
madam, obtained from the
No,
court's
that
website.
is a different issue.
It was filed, madam, on 7/6, but with the on the strength of the copy, madam, taken from the website.
No.
And I applied for the certified copy and also filed it. That was the certified copy was filed on 27/6.
Oh, no, it is filed and presented in 7/6.
Yes.
Vacation started when?
19/5.
19/6. 19/5. Regular filing takes place during the vacation also.
I couldn't follow.
Regular filing takes place during the vacation
Yeah,
also.
but that was, I don't dispute that.
No, non-filing of the certificate can be a defect, but presentation cannot be a.
So then there is no delay.
There is
In
a.
appeals, it is taken that unless you file the in order, it is not valid presentation. That will be shown.
Have you filed the certified copy now?
Yes, on 24/6, madam. They have
That
taken
date
that
has been
27/6, I have filed certified.
That is the reason that they say the 27/6. Anyway,
Because there was also a delay, madam, in getting the certified copy. Applied on 2/6, got it, madam, 24/6.
24/6. You got it on? Applied on 6.
Applied on 2/6.
Got it on 24/6.
24/6.
So that means 18 days.
Yes.
Then you should have got it. No, but limitation would have expired on. Then ताले भी हवनी. Dispose on 24 हेले अपन को 23/5 को होची. Setar haban. We have to take it je apna jo file korchindi on 7/6 as per that. All right. Certified copy period ta actually भी सही आड़ू मिली वन. But that expires within the vacation.
But she came to know about the order not subsequent that it's
But counsel appealing to the appellant. From the stamp report, it appears that there is a delay of 34 days in filing the appeal
The private party involved.
against the order dated 24/4/2023 delivered in WPC within bracket OSC close the bracket number 3082/2017. By the learned single judge. The memorandum of appeal was presented on 7/6/2023, but without a copy of the without a certified copy of the impugned order. So, as a result, the stamp reporter has shown the aforesaid delay. In our considered view, since the memorandum of appeal was filed by an uploaded order, by copy of the impugned order, it is a case for defects, but the presentation of the appeal cannot be but the presentation of the appeal cannot on 7/6/2023 cannot be denied, stating that there was no valid presentation on that day. True it is that in absence of the certified copy, the appeal may not be admitted, but the presentation cannot be refused. It has been stated by Mr. Tripathi, Learned Counsel. Letter on the certified copy has been filed on 27/6/2023. Step. In our considered view, there is no delay. As such, it is the pass the order in the I number 3799. This is this application for condonation of delay plans to be inconsequential and according this application stands disposed of. In view of the order next appeal, in view of the order passed, appeal, some other day we'll list the appeal. Order passed in sentences. This appeal will be listed on 24th of July. 24th of July, 23. Mr. M.K. Kunti, additional government advocate, has appeared for the respondent on advance notice.
25.
I please your lordship. Here, no, this is I'm appearing for the opposite party. No, this is a prayer for the PIL, prayer for construction of pedestrian underpass near Birabhadrapur, near Puri, in the state of Bhubaneswar Puri section of National Highway number 203 Manor. So, with regard to prayer of the construction, the National Highway Authority on 1st March 2023
has accorded in principle approval for construction of such PIU.
Can you show any paper?
My lord, yes,
you-
I filed that. I filed that
Counter affidavit.
1-3 affidavit filed on behalf of NHI in compliance to order dated 16/1/2023. That has been.
In the meanwhile, the that opposite respondent number 1, executive engineer, then it was under SESU. Presently, it has been taken up by TPCODL. So he should be made a party. Accordingly, I filed IA number 3622 of 2023.
3622 of 2023.
3622 of 23. With the prayer to
You want the substitution because of change of the management?
Change of the management. Now no one is appearing for SESU, and no one is also receiving the copy. So we have to take notice, my lords. There's no option like.
Or Mr. Just
Hasn't their nomenclature also changed? Some TDP, PPD call?
TPCOLD represented by divisional manager.
That has been changed.
of 2023.
This doesn't show.
Earlier it was executive engineer, now divisional. Earlier managers, executive engineers under SESU, now they are redesignated as a divisional manager on TPCOLD.
No, for
Isn't it
TPCODL, my lord, I have already entered appearance.
Yes.
TPCODL already entered appearance, my lord.
Then my lords may be recorded, my lords. I will serve copy to additional affidavit, my lords. It is better, my lords.
You have already entered in the appearance.
Yes, yes, my lord.
So there was substitution. How can he otherwise?
No, my lord, subsequently,
Earlier he was appearing for SESU.
my lord,
You
when
are
the
for the
brief-
SESU.
No, my lord, initially SESU council was appeared. My lord, subsequently it be transferred to me, and through the executive engineer TPCODL, I have appeared, my lord.
All right, my lords, it is better, my lords.
Okay.
It may be, I will file.
All right. I'm just passing the order. Hear me. There is a petition for substitution of TPCODL within bracket Tata Power Central Orissa Distribution Limited in the place of SESU within bracket. SESU is the Central Electrics
SESU, Central Electrical
Electricity Supply
Central Electricity Supply
Unit. What is there? Supply unit.
TPCODL, my lord, Tata Power Central Orissa Distribution Limited.
SESU, I have given my emails in my first title, Central Electricity Supply Unit.
Central Electricity Supply Unit. Which was represented by the executive engineer. Stop. Since the management has been since the management has been changed and EODPCL has taken over the management of the said distribution unit in place of respondent in place of SESU, executive engineer SESU, the divisional manager TOPDCL will be substituted as respondent number 1. Stop. Mr. S.C. Das, learned counsel, has already entered in the appearance for TUDPCL, divisional manager TUDPCL. Therefore, no formal notices need to be passed. the appellant is directed to furnish the amended cost title within a period of 3 days from today. Let the appeal be listed again on 10th of July, 2023.
10th of July, pre-matters may be taken up on 14th of July. 14th.
This court will 17th July. What kind of affidavit you are asked to file?
So I was required to file. I relied upon few documents in different cases. I was required to file an affidavit in the form of additional.
Meanwhile, the appellant may file the affidavit.
Yes.
In terms of the order dated 3/4/2023.
Yes, we filed that affidavit. We will serve a copy to Mr. Das. We already filed. Yes, we have already.
It has been stated by Mr. Mahapatra, learned counsel appearing for the appellant, that the affidavit has been filed in terms of the order dated 3/4/2023.
Yes, or 26/6/23.
No, this is 3/4 also says place and record the certain orders of such and such, as well as the code in the form
I
of an
have
affidavit.
all those. I brought it in form of an affidavit.
All right, that affidavit you have filed.
Yes.
All right. Mr. Mahapatra, learned counsel is requested to furnish a copy of the said affidavit to Mr. S.C. Das, learned counsel, within 3 days from today.
Right.
29.
29. The appellant is a central cooperative bank, my lord.
Yes.
The respondent number 4 is the has a joined in our bank on 12/11/2003 and retired on 30th/11/2003. Only 19 days he has served. But the Regional Provident Fund Commissioner decided proceeding under para 26B that he is our employee from the with effect from 11/9/1964. That proceeding was challenged before this honorable court. I have implemented government and registered cooperative society Odisha, who is the statutory authority under Odisha Cooperative Society Act. They have not filed their counter. This is a policy decision, my lord. Register so many times stated that.
How it is a policy decision?
Policy decision means, my lord, the government of Odisha, registered cooperative society Odisha framed a staff service rule 1980. In the staff service rule, the society employees were included.
Yes.
And they were deemed as a bank employee with effect from 28/2/2003 as per the order of the government.
Yes.
The employee, opposite party number 4, joined in our bank on 12/11/2003 and retired on 30th/11/2003. But the Regional Provident Fund Commissioner, opposite party number 3, respondent number 3, declared as our employee with effect from 1964. At that time, he was the employee of a primary cooperative society. My responsibility submission,
Whether the primary cooperative societies are entitled to get the benefits.
My lord,
they are also entitled
in the Odisha, three types of
cooperative societies are there.
Our bank is a central bank, stage 2. Before
Central bank.
Central bank.
How?
Then Apex Bank Odisha.
You can say the Apex Bank, don't say the central bank.
17 central banks are functioning in the state of Odisha. Central Cooperative Bank. Central Cooperative.
Apex Cooperative Bank. Anyway, Central Cooperative Bank. Yes.
The opposite party, respondent number 4, is the employee of a primary cooperative society, Bodpolosa Service Cooperative Society. Registered cooperative society, statutory authority, in different cases stated that they are entitled, they are all benefit from the primary cooperative society. And they are
benefit the petition, this writ petition will get.
My lord, I have filed a writ application.
No, yes. What benefits are writ petition is entitled to? Tell us. What benefit?
My lord, gratuity, provident fund, retirement benefit. My responsible submission, respondent number 4 is entitled his gratuity leave salary only period 12/11/2003 to 30th/11/2003 or the government declared as a bank employee with effect from 20th to 2003 only. In this case, Honorable Chief Justice of Odisha and the Division Bench directed to the government to file a counter in the last date.
Yes.
Because in read petition, they have not filed counter. The government may file counter. In so many cases, similar cases are pending, claiming gratuity, and there are other entitlement.
For the registered cooperative societies.
I am appearing.
Government. You have not filed the.
I have not filed a counter. This is my
Last order was passed in the month of February 2023.
My instruction will come since nothing affects. I mean,
Someone
the order
is out
does
of
not
service.
affect.
Whether we let us decide whether he is entitled to any benefit
Yes.
or not.
No.
And if he is entitled, who will be responsible for making the payments?
The regional provident fund commissioners.
No, only the EPF. He says gratuity also the issue. That is, I asked him, and council is appearing. Then what is the benefits this writ petition will get? He says gratuity also they involve.
Yes.
Gratuity, the EPF commissioner has no role to play. He only just pension under the EPF scheme of 2006. New amendment in 2006.
Shall I submit one thing? I am appealing for the regional provident commissioner.
Yes.
In the writ application, nothing has been prayed. In writ application, they have prayed to quash the order passed under paragraph 26B of the providential scheme. 26B says, if any employee will file a petition regarding the debt of his membership, then the matter will be noticed to the employer, and an inquiry will be conducted under paragraph 26B, and order will be passed. So an order was passed in favor of the opposite practice respondent of 4. After that, the bank millets, he has filed a writ application, and the prayer is also can see the page 34 of the brief millet. This is the prayer made in the writ application.
Yes.
Page 34 millet. Why the implement order that is such and such of the opposite party number 3 under paragraph 26B, EPF scheme in respect of petition of bank, such and such number, unanswered says shall not be quashed. So only prayer is made to quash the order passed under 26B. Then Millers, the Honorable Single Judge Millers passed an order that is the relevant portion is 120 of the brief millet.
My lord, that will
just please wait.
The government will say that he is our employee or the employee of a bank.
The government will not say, my lord.
No. Government counter is highly necessary, my lord, in that case.
Please wait.
My lord, I have a challenge the order of the Honorable Single Judge because
no, your objection that he worked with you only for 19 days. So you have no responsibility. This is your case.
Yes. Because he is the employee of a primary cooperative society. It is a separate entity, separate management. And he was drawing salary from the primary cooperative society, not our bank.
No, at no point of time he drew the
yes,
salary from you.
Yes. My lord, Annexure 11, the on a registered cooperative society has decided in case of a Noyagada Central Cooperative Bank that the employees, cadre employees are entitled their dues from the society. My lord, same opposite party number 3 decided another
Why
case
the
of Moyurbhanj.
EPF commissioner is not releasing the pension of that person?
Yes, millets. Regarding membership millet, he has to file a petition under paragraph because the employer has to send the information to the RPS millets. But if any member wants to challenge that order that my membership must be decided from which date, then only millets they will make an inquiry. They also kindly turn to page 120 of the brief millet. That is the order passed to the single judge. The relevant portion page is 120. Let's got him that. Page 120 of the brief. That is the order passed on the single
Same authority.
Just please wait.
Movie Annexure, my lord, Peru, the Annexure 9, same authority. Opposite party, respondent number 3 has decided in Moyurbhanj Central Cooperative Bank the cadre employees are entitled their retirement provident fund with effect on 28 to 2003. In our bank, that is a separate.
No. Just wait.
17 central bank are one
You didn't
regulation.
have any prayer in the writ application? You
No,
wanted a prayer to.
No,
quash the order passed
I
on
have a
consensus?
prayer. I have a,
What you have prayed?
I have
Please
a-
go to your prayer.
No, my lord, I have categorically prayed to quash the annexure 8 part by the respondent number 3, my lord.
Yes.
How the respondent 3 say that he is our employee without evidence, without producing his appointment order. My lord, we have never issued our appointment order. My lord, peruse the annexure. My lord, peruse annexure 6 joining report of respondent 3 page 53. Annexure 6 page 53. The respondent 3 join our bank on 12/11/2003. He submitted his joining report. Page 53, my lord, in my writ petition. That has not been decided by the honorable single judge, my lord. Not a I have although annexed all the annexures, but that has not been considered.
Yes.
Can you turn to page 120? That is the relevant portion of this order passed by the honorable single judges. Moreover, the petitioner in pursuance to an inquiry initiated not section 7A of the EPF, which culminated into final order under section 7A, has preferred an appeal under section 7.2 before the tribunal, which the petitioner has also assailed the order passed in the authority under section 26B, and the same has been told to be pending before the appellate authority. What happened, Millard? And a petition was filed before the authority regional permanent commissioners under paragraph 26B. Shall I place on paragraph 26B?
26B power has not given to quash the appellate authority has no power, my lord. I have prayed more prayer, but that cannot be accepted.
Which appellate authority? Have you filed any appeal?
Appeal, I have filed appeal challenging the order on 7A proceeding. That is a separate proceeding. My lord, same person, the opposite, the respondent number 3, part 2 orders. One proceeding order which under para 26B of EPF scheme, another order which under proceeding 7A of EPF proceeding. That was challenged before the appellate authority. That is in no way related to the no way related.
No, complete misleading.
No, I am not misleading. This is a provision of law.
No.
My lord, government may file counter because
no counter is necessary.
No counter is necessary.
Learned counsel for the RPS.
Let me submit first.
Let him complete his submission.
Then you interfere. See, paragraph 26B of the Employees Provident Fund scheme says, if any question arises whether an employee is entitled or required to become or continue as a member, or as regards the date from which he is so entitled or required to become a member, the decision thereon of the Regional Provident Commissioner shall be final, provided that no decision shall be given unless both the employer and employee have been heard. In this case, Miller, the appellant, so in this case, the member, he has filed a petition under paragraph 26B. So an inquiry was conducted by the competent authority of the PFO, and the order was passed that the petitioner is entitled to the benefits from the date from which he is entitled. Then what happened, Millers? After that, Millers, an inquiry was conducted under section 7A for determination of the amount what the establishment will pay towards the dues of the concerned employee. That 7A order was passed, and at that stage, Millers, my friend has filed an application stating that praying to quash the order passed under 26B. The matter was heard and counter was filed. Then, Millers, the Honorable Single Judge passed an order that the 7A order, which clubbed with the 26B, has already been challenged in the appeal. Moreover, the order, the original portion of the order says, Millers, moreover, the petitioner in pursuant to an inquiry initiated under section 7A of the EPF Act, which culminated into the final order under section 7A, has preferred an appeal on section 7.2 before the tribunal, in which the petitioner also asserted the order passed by the authority under section 26B, and the same has been told to be pending before the appellate authority. The appellate authority has the tribunal, Millers, he decided the matter. Then Millers, the bank, Millers, he filed another writ application bearing WPC number 18968 by 2018. So how the writ application is maintainable? And that too, gratuity is concerned, Millers. The bank has given gratuity to the employee, Millers. That is, you also can turn to page 80. Page 80 of the brief answer A/3. The Keonjhar Central Cooperative Bank Ltd. Letter of such and such. So this is the respondent number 4. Statement of gratuity bill of Masudan Pati, retired junior supervisor. Then where the bill was processed and paid. How are you saying that gratuity? Gratuity has was not subject matter of the writ application. The subject of the writ application, subject to the writ application was there regarding the debt of his membership under EPFO. So that was decided. Then Millers, for quantum, because in 26B, once the debt is decided, an inquiry is conducted under section 7A of the Act to determine the asset, to assess the amount. What is the amount is due? After that, Millers, the petitioner challenged both order passed on 26B as well as the order passed on section 7A of the Act in the tribunal. In that stage, he also filed another writ application before this honorable court. The honorable single judge, Millers, after hearing the parties, Millers, found that both the 7A order and also petition 26B are pending before the tribunal. Then Millers, then the order was passed, directing that they let the tribunal decide the matter. Yes. So the tribunal decided the matter and he dismissed on 7/9/17. After that, the petitioner challenged that order in this writ application number 18968 by 2018. So how the writ application is maintainable? Absolutely, the writ is not maintainable at all.
All right. Are you serious to file an counter affidavit?
No, my lord, my instructions, in fact, after communication are very clear. My instructions are, since none of the actions of the Register of Cooperative Societies has been challenged, nor any relief has been sought from the register by the appellant, hence we are not submitting any para-wise comments.
We provide them a short time. That is, we heard the matter. Let them file the affidavit. Transfer has taken place at the instance of the Registered Cooperative Societies. Because between the two cooperative societies, the transfer has been placed because he was working earlier under these other cooperative societies,
Yes,
the
yes.
Credit Society. Now he has come to the bank.
Yes.
So the Registered Cooperative Society was instrumental to place his service to the bank.
Yes, he is a rule making or also staff service rule framed.
My lord may grant me that time. I'll again communicate. If they don't give any instructions, my lord may proceed on the merits.
All right. At the request of Mr. D. Naik, Client Counsel appealing for the, you are the respondent number? Respondent number 1 and 2. Let the matter be listed on 27th of July.
Millers are not concerned, not in force Miller. Let it do 28th Miller.
28th July 2023. Meanwhile, the opposite party number 1 and 2. May file the counter affidavit as they were granted leave by the order dated 6/2/2023. It is made absolutely clear. No further accommodation would be made. Stop. You are Mr. Boidur Sahu.
Baidar, sir.
Blood counsel is appeared for the appellant and Mr. Your name?
SS Mohanty.
SS
Mohanty.
Mohanty, learned counsel is appeared for The opposite party's number
Three.
opposite party number 3. There is no representation for opposite party's number 4.
3, my lord. Only 3.
I'm three. Only three.
Is 4, but 4 there is no representation.
No, yes.
Despite due notice from this court. Notice
By
you took
their-
steps for service of notice.
Four.
Have you taken step
Four
for
actions
service
are
of
by-
And already notice issued, my lord.
Yes,
Barik
see,
is appearing
but
at
it
it,
did
yes.
not appearing.
No.
No, he's Barik, some Barik appearing, most probably.
Bari.
Some Barik is appearing solely because nobody
Alright.
appearing with me. I am arguing.
None appears for the opposite party number 4 today. All right. It will come on 28th of
My lord.
July. You just give us a short note.
Yes, my lord.
I will also give. I will already I filed a counter to the Rita bill. But though not necessary.
Because one
I will
issue,
give it that.
one issue is troubling us is that even if you are the employee for the other
No,
cooperatives.
all appointments were given by the bank.
My lord, my
complete everything just a minute. Everything is settled in the the appeal which was filed before the tribunal. Everything has been settled.
No.
All the
The
documents.
tribunal matter is a separate, my lord.
Next
Tribunal
time,
matter
okay.
is a separate. Yes.
Item 30.
May I please your lordship, my lord, before my learned senior starts, my lord, I am appearing for the respondent number 3, my lord. My lord, there is no instruction and there is no response from the respondent 3 whether he is interested to contest the case or not.
Okay.
Therefore, since the last occasion, this honorable court directs me to appear for the respondent 3. Therefore, I may be granted one more chance to intimate him whether he is interested or quit from the.
Why should you give any more chance for taking in?
Can you see the last 3 orders passed by this?
That is what. Why? We'll hear.
Let's say here, but no instruction from my.
No, you don't submit. We will record your submission.
Yes.
Now, Lord, we are for the appellants here. The Institute of Technical Training Sundar, it's a private engineering college. That is the appellant.
I don't think this matter can be completed today. It's already 3:30. So what we do is fix it some other day.
May I, sorry to, the respondent 3 has filed a fresh power in favor of my learned brother. Therefore.
Yes, lordship. In the opinion number 3, lordship, I appeal, lordship, respondent.
No, not today, some other day. We're fixing a date.
August. In August.
In the month of August, 4th of August.
But may I just place a small request? In that case, if Lordship would kindly see the list, a wrong repetition has been tagged. Let that be also a correct matter which is required for the purpose of adjudication. Let that also list as a comment. That is, this 9384 is the incorrect number. Kindly see serial number 30.
Yes.
There are 2 matters tagged along with this letter bill. After that 12,697 of 2019, WPC 9384 of 2018 has come for reference. In fact, this is not the correct matter. I am giving the correct number.
9438. Which part of
9438. The number
Which is-
should be
which is the order?
9438.
Which order you are referring?
But I am referring to the impugned order in some other matter, 12,000 some 12,697 blood, the impugned order. That is at page 12 months. But all these matters have a bearing with the adjudication of this because they earlier approached in these matters. They got some order was passed with regard to maintenance the writ petition. They suppressed this matter in the subsequent writ petition, which were from the impugned order is arising. Now they got the order suppressing the fact that earlier there was already an order passed in other writ petition.
All right. The shortage of time, the matter cannot be heard today. Let the matter be listed on 4th of August, 2023. Mr. P. K. Rath, London Senior Counsel, listed by Mr. Behra.
Yes, Mr. Behra.
Mr. S. K. Behra, London Counsel for the appellant.
Respondent number 3.
And you are appearing for respondent number 3.
3, Arun Mohanty.
Mr. Arun Mohanty, London Counsel is appeared for respondent number 3. You are not there now. All right. In view of the order passed, all the petition are listed on the same date. List. In view of the order passed in WA 368 to 2019, list this petition on such and such date.
31.
Lordship also said that 9438 to come along with this appeal. 9438 of 2018 to come along with this matter for reference of the Lordship.
439 of 2020.
But 9438 of 2018 is the correct matter. That only I am sorry, my Lord, I am troubling you, Lord.
Okay. All right. If any correction is required, you just give a slip that we will.
I'll give that slip, Lord. That will be fair.
31 April next. 31 April next week, my Lord, I am appearing for the respondent.
Which one matter?
Item 31.
You are Mr. Mishra?
April next week.
You are Mr. Mishra?
On behalf of Mr. Mishra.
What is your name?
My name is Senapati, Sangram Senapati.
The request to Mr. S. Senapati, Learned Counsel, appearing on instruction of Mr. L.K. Mishra and Counsel for the appellant. Let the matter be listed on 7th August 2023.
First week of August.
7th August. Who? The appellant. You have appeared to the respondent?
Yes, my Lord.
Oh.
Appellant, my Lord, senior.
Yes, Senapati and counsel for the respondent, huh? Say on instruction. All right. Okay. Next.
32.
Lord, I'm sorry, my Lord. Again, I'm sorry to trouble, my Lord. In that item number 30, entry models to continue, my Lord. That's it. I'm sorry, my Lord. I forgot it to mention.
But if correction matter, you just give a slip. Entry model, if any is passed earlier, shall continue. This is in order number 30. Huh?
33.
Next.
32.
May it please your Lordship. It is that amendment of that Gram Panchayat Grab Rozgar Sevaks appointment matter laws. The Lordship had extensively my Lord Senior AG as well as Mr. Dalai.
No, today is only for you and time duration is at 10 minutes. According to your request, we have granted you 10 minutes time.
Lordship, in fact, I had undertaken to complete it within 15 minutes, but as per my prepare, it will take some time.
No, that's you completed today.
Lordship, I am trying to complete the same, but it may because some provisions have to be read out and to bring to Lordship's notice that the
which are the provisions? Those who are not read out to us, new provisions.
That again I want to.
No, not required.
Lordship, because from that provisions I will Lordship, try to persuade a Lordship that the amendment which under which the executive officers Lordship, that has been amended, that's completely in derogatory to the statute. Remember that I will bring to Lordship's notice with a reference to the various provisions that absolutely it has no scope under the act to appoint such Lordship, give such appointment. Lordship, yesterday also Lordship, I think your Lordship is convinced that the amendment which is also contrary to the provision, but we have not specifically made a prayer to quash the same specifically. Lords, even if that is the position, Lords, I have made Lords a prayer that any other directions which may deem fit and proper for the ends of justice. Lords, in the ground we have specifically stated that this is contrary to Orissa Gram Panchayat Act and rules. That is there. I had drawn your lordship's attention. Your lordship kindly again bring to lordship's notice that, and our High Court judgments also with regard to that. If specific prayer is not made, and a prayer is made that any other order direction which deemed fit and proper be passed.
We know if we can hold the relief, there is no difficulty, but you come to the point first.
Lords, therefore, even if we have not
admit this proposition that the 122 was generally challenged before this High Court. High Court refused to interfere with subsection 1 and 2. But it kept it struck down this subsection 3 only.
There, my lords, what I beg to my lords persuade your lordship, because of 122 subsection 3, the entire provision 122 and 130 held to be inoperative, invalid. Now, not only that, because I am trying to persuade your lordship, only because of that, these two provisions have been held to be invalid, inoperative. That it is not, to my understanding, it is not exclusively that under subsection 3 and subsection 122 only, because of that the entire lord's amendment was held to be invalid, inoperative.
Entire 122?
Yes, my lords. That last
make a submission.
Bringing to lordship's notice, because this section 3 and subsection 3 and section 122 Lords,
come to the judgment.
Lords, I am reading out the judgment first.
If the copy of the judgment is there, by scanned yesterday's papers.
Yes, sir. Scanned.
Huh? Okay.
Fakir Mohan Das and others.
Yes, read.
Lords, paragraph 18. Argument of the petitioner is that event of conflict between the rule and the act, the rule shall prevail, and because the amended provision of section 122 is in conflict with rule 212, the amended provision of the act will be of no avail. Such argument has no legal force in as much as it is the treaty of law that in the event of any conflict between the act and the rules made thereunder, the former will prevail. At the same time, it is the treaty of law that rule framed in any statute should be in conformity with the act, not in deviation, derogation, and contravention of provision in the act. Therefore, the rule which in existence conferring the different rights and duty to the secretaries of Gram Panchayat is automatically taken away by amendment of sections 122 and 123. However, so when subsection 3 and section 122 confuses the issue, look, this strikes my mind. What I beg to try to persuade a lordship, because of this 120 subsection 3 of section 122 confuses the issue and makes the provision section 122 and 123 inoperative in its amended form, and hampers the right of panchayats in the matter of self-government, and the orders under Annexure 1 and 3 cannot be accepted as illegal, valid, and in conformity with Article 243G of the Constitution. For the aforesaid reasons, we dispose of the writ petitions with the conclusion that the provisions of section 122(3) of the Act ultravize the Constitution, and in view of that amended provision, this your lordship kindly mark, in view of that amended provision in section 122, 123 of the Act relating to appointment and functioning of executive officers cannot be done validly legally. As consequences thereof, circulars under Annexure 1 and 3 are also quashed. So in entirety, the circular which was under challenge, that was quashed. So my humble submission before lordship is, because of the confusion arising out of that subsection 3 and section 122, the entire provision of under section 21, 22 and 13 became inoperative and invalid. For that reason, my lords, the appointment of the present fact in issue with regard to amendment and appointment of executive officer is contrary to this statute.
You come, the relevant paragraph you marked that you have read now. You have read to
Plus,
Fakir
I'm
Mohan.
reading the provisions, Lords, which I have specifically said.
No. Read the relevant paragraph from the report you have relied on, Fakir Mohan.
Paragraph 15 I have. Lord, say, paragraph 15 I insist on that paragraph 15 of my page 23 of my brief, that is the second brief in the cause list. That number is 226464.
Yes. So according to you, the entire section 122 is inoperative. Okay.
Paragraph 15 I have specifically pleaded with that. Then Lordship kindly say what I beg to bring to Lordship's notice with regard to that appointment of Lord's Gramo Sabha, Gram Sassan and all that. There Lordship will find only the Gram Panchayat is authorized to appoint. Lords, here in this case, Lords, there is no provision under the rule to control and guide this executive officer. No rule has been amended. Still, it is the Gram Panchayat secretary. The Lordship kindly say.
Yes.
The Lordship kindly say section 2G of Orissa Gram Panchayat Act. My learned senior learned AG has pointed it out. Again, I am bringing to Lordship because to coincide this submission, Lords, I am bringing to Lordship's. Gram means a gram constituted under section 3. But that has been read to Lordship. Then Gram Sassan means Gram Sassan established under section 4. Then your Lordship kindly see the section 5. Gram Sabha and its function. There shall be at least 2 meetings, one in February, other in June every year of the members of Gram Sassan. Such other meetings as may be prescribed. The quorum for the meetings of Gram Sassan herein referred to as Gram Sabha shall be 1/10 of the members of the Gram Sassan. B. The event these being no quorum of Gram Sabha, it shall be stand adjourned to future day, which notice shall be given in the prescribed manner, and no quorum shall be necessary for any such adjourned meeting. Gram Sassan shall have the power has been given, approve the plans, programs, projects for social, economic development before such plans, programs, and projects are taken up for implementation by the Gram Panchayat. Identity select persons as beneficiaries, so that not relevant. Consider and approve the annual budget of Gram Panchayat, including supplementary or revised budget. Then let's skip over to consider all such matter as may be referred to it by Gram Panchayat for its decision. Call for such information data from Gram Panchayat as may consider necessary. And these are the prescribed powers authorized under Gram Panchayat Act.
We are not concerned. Where are you reading? We are not concerned. Only issue is very pointed.
Because what? Even in case of appointment, only the Gram Panchayat is the authority can give appointment. The rule has also been framed because the whatever decision will be taken in the Gram Panchayat, that has to be approved by the collector. And this provision has been superseded in the impugned amendment. They have inserted this power, even though I have not specifically, because I am sorry, and your Lordship pointed, I am really grateful to your Lordship that this aspect should have been prayed for specifically. But Your lordship may kindly come to my rescue because thousands of Gram Rozgar Sevaks are also before your lordships, and your lordships also intervening in their matters, granted interim order, they are also continuing. Lord sir, yesterday your lordship also pointed out, I am grateful to lordship, with regard to there is no provision for the overaged employee beyond 35 years. There is no such consideration for these Gram Rozgar Sevaks. Lord sir, not only these petitioners which are before lordships, thousands petitioners would be.
Yes, Learned Council, that one thing you must appreciate,
My lord.
that regularization cannot be directed by the court.
My lord.
Only if the two conditions are satisfied, court may direct. At the time of appointment, number one, if they were appointed against a particular post,
My lord.
the vacancy was there, and they are discharging the same post for a long time, and their appointment was made through a transparent process, then the two conditions are fulfilled. At such situation, we may ask the state government why they are not regularly appointed. If they cannot show any valid reasons, court can direct. Right? But here then, just first of all, you consider this is a central government project, and you are appointed under the central government project, and your authority has been given to the Gram Panchayat. What you will serve? And in the central government, the general principle of law is that when someone is working under the project is over, his engagement is also over. So there is no permanent character in this engagement. Government as a welfare measure, in the 2008 rules has made an accommodation. If from the VLWs the persons are not available, then in the post of this executive officer, they can be considered to an extent of 30% of the total strength, right? And then this 2014 amendment has taken away the entire thing. Now there is nothing of that sort. The question is that whether the court can direct the state that your amendment is wrong. Only at one single incidence, when such direction can be passed by the courts, if the court finds that you had a vested right over the post and that has been taken away. Here the case is not that. You understand that this is not you don't have any vested right on any civil post. The first civil post you are confronted either from the 2008 rule is the VLW. Right? Now the VLW post is also obliterated and they have been merged with the newly created post of the Panchayat Executive Officer. And while framing the rules for the Panchayat Executive Officer, the GRS, they do not have any accommodation, they will not be considered. Your grievance is that has been taken away, and accordingly, this rule should be struck down, and the opportunities, as was earlier rule, they should be created. Well, now the question, last occasion also I asked whether the court can pass such direction or not.
Lord, sir, there my Lord AG pointed out to Lordship by that Himachal Pradesh judgment. There the Lordships have categorically held on the last that if Lord, I am bringing you again to Lordship's notice.
No, there is not only that judgment, there are several other judgments.
Your Lordship can consider this. That is there. If Article 14-16 is brought, Lord, sir, bring
that is one case already. Mr. Doloi yesterday was referring to our judgment.
Lord, they are also specifically stated that if this is Lord's discrimination is pointed out, then also can Lord's your Lordship can come to the rescue of this.
Yes. But the cut-off date, so far the age is concerned, unless you can show that the cut-off date is absolutely unreasonable, can the court interfere? Cannot.
Look, in the present fact also, Lord, there are some Lords I have enclosed recently with Lords, other parts are there also. I want to bring to Lordship's notice.
I think you are now to close within 5 to 10 minutes because we have no time.
Millers,
we will not allow you to spill over to the next date.
Millers, the annexure, your Lordship kindly see my rejoinder I have brought to your Lordship's notice. Annexure 18, that is page 151 of my brief.
There is 22464.
Yes, my lord. 22464.
Annexure?
Annexure 18, my lords. 151 page.
You are referring to the writ petition.
My lords. The office order of the plus collector and district magistrate Kendrapada.
Annexure, you are referring?
18, 151 man. Page 151.
Page 151.
Yes.
We're not getting in that writ petition.
Which writ petition?
Lord,
Which writ petition?
my lord, second writ petition. 22464.
Annexure 18.
15 is the last annexure. According
Lords, thereafter, I have
There
got
is
it
no annexure 18.
reconciled, my lords, from the brief or lordships brief, my lord, code brief today. That is
no,
151.
we are seeing the scanned copy. There is nothing of that sort.
That is, my lords, a rejoinder, my lords, copy that is enclosed in my rejoinder.
There is no rejoinder.
18.
Rejoinder affidavit.
Rejoinder with the petition.
151.
You rejoinder 151.
Yes, my lords.
Okay. Rejoinder there is 18. Annexure 18. Annexure 15 is there.
151.
Rejoinder annexure 15.
Annexure 18.
Not 18. 13, 14, 15 are the annexures to the rejoinder. What is the document?
That is the document
Dated?
dated 17/8/2021.
This is office order.
Yes, official.
How does it support you?
My lords, because after the amendment came into force, my lords,
Yes.
first of all, I had, my lords, tried to persuade a lordship that it has no, so far the Gram Panchayat Act and rules concerned, it has no application. And
No,
second thing, lords,
this
if
is
the
a-
lordship comes to conclusion
Ah.
that the amendment operates, and we have, since we have no specific prayer with regard to that, lords, this is a discrimination, because even after the amended rule came into force, they have given appointment to employees, Gram Rojar Severs of the Kendrapada district and some other district also. This has not been controverted or denied in their reply notes.
Mr. Advocate General, this is a very typical order passed by their state.
But I was just having a look at it, Lords.
When this rule was already inoperative.
I'll tell you, Lordship, what may have happened. I'm not sure. Your Lordship may see this order is 17th August. And this rule has come into force on 7th August. So maybe this order had already been passed by that time. I will have to check up on this.
Please check up, because there is a serious confusion.
I will check.
In fact, Lordship, may I clarify this issue, Lordship? May I clarify this issue, Lordship? In fact, Lordship, all the selection procedure, they are making by a cadre procedure, Lordship. They are making a cadre and accordingly they are giving promotion. In fact, before coming up this rules, Lordship, all the districts have completed their selection procedure. So that's why some of the collector understood the order, Lordship, because they have completed, they gave appointment. And many district Lordship, they are saying no, because this rule has come up, will not interfere. In fact, more this is a, let's say, confusion in interstate. By this process, Lordship, 3 to 4 districts given promotion, and rest of the districts, because we have already cadre has been selected and we have been promoted, we have been enter selection process completed, but they are not giving promotion due to this Lordship upcoming these rules.
Okay.
So that's why onward single judge is given stay in every district, perhaps Lordship, to keep reserve that post, Lordship.
But that interim order is no more there.
Lordship.
This interim was still continuing.
Stay is continuing, Lordship. In other case, stay is continuing, still continuing, Lordship. Many cases, all the perhaps almost all decisions have come of this Honorable Court, Lordship.
No, that is my question. You must answer that. How does it help you? Because doctrine under the doctrine of equality under Article 14 is not is a negative concept that someone has been wrongly given any benefit that you cannot deploy for claiming any right. It must be the positive. It must be tested through the law. If someone has done a wrong thing, someone has committed a mistake, erroneous order has been passed, those cannot be based for claiming any relief on the basis of the discrimination.
Lord sir, they have, Lord sir, not that they have wrongly given it, because they have prepared the gradation list, invited objections. After finalization of gradation,
So the gradation is not in dispute. Try to understand this. Gradation, we are not on gradation. We are simply that the GRS right has been taken away from the zone of they are no more in the zone of consideration. The rule has come into effect, and your contention, this order dated 17/8/2021 was passed after the rule has come into force, and they are still allowing the GRS to be considered for the post of this Panchayat Executive Officer, why not the other GRS? That is exactly the point you have raised.
Lordship also kindly see, this rule have no retrospective effect. It has no it is prospective. Lord, they have almost all completed the procedure to give engagement to these GRS. Even before just 15 days or 2 weeks, 3 weeks, or some like that, they have prepared the gradation list. There are a series of correspondence. Because your Lordship give me time, I will also bring to Lordship's notice, specifically the Secretary of the PR department, specifically issued guidelines.
That not in your writ petition, Learned Counsel.
Lord, I have enclosed the documents. That is under annex.
There is no averments.
Yes, averment is there, document is there, annexures there.
Read the averments regarding this. This you have referred this. I've checked right now. Just come to the averments about the other things.
Yes, Lord. Your Lordship kindly see.
Come to your writ petition.
Yes, Lord. I am bringing it to Lordship's notice. Fixed by A and Lord's paragraph 6. Paragraph 6.
Of the writ petition.
Yes, Lord.
Yes, read paragraph 6.
Lord, sir, may I read paragraph 5 first, then we will bring to Lord, invite to Lordship's attention. That while position stood thus, the state government in Panchayat and the drinking water department floated a comprehensive guidelines by its order dated 6/4/18, which was concurred by the finance department for creation of 567 new posts, increasing the total of number of posts to 6,801. In this said guideline, eligibility, educational qualification, criteria for selection, advertisement, ORV Act, panel of merit list and cadre, preparation of gradation list, remuneration, transfer of appeal, etc. have been provided. The gradation list of GRS have been prepared since 2013, and according to the gradation list, at the first instance, 19 GRS were promoted to the post of BLW, and in the second phase, in the last year, that is on 2020, 42 GRS have been given promotion to the post of PO. The opposite parties, even though having sufficient number of vacancies in the post of PO/BLW, but in a discriminatory manner, given promotion only to few people on the basis of seniority, and others were awaiting for getting promotion to the post of PO/BW, as and when government decides. The gradation list of GRS to so prepared by the collector were duly circulated amongst the employees, and after getting the objection, same was made final. The final gradation list of GRS Mayurbhanj district 2020 was circulated by the collector Mayurbhanj, is annexed here with answer 5. Then para 6. That it is further humbly submitted that initially 19 GRS out of 2013 gradation list were promoted to the post of BLW. Thereafter, opposite party stopped giving promotion to GRS illegally for the given years, and only on 13/12/20 gave 42 GRS to the post of PO. Copy of the promotion orders to 19 GRS on 12/24/12/13 are annexed and 6, and order dated 30/12/20 is annexed and C/1.
No,
So,
that's right.
Yes,
That's right. They are granting under the 2008 rules.
yes, 18 and 13.
Huh.
18 and 13, that has now
Because the new rules came in the 2021 only.
then
Before that, there was no problem because the rules provided that the GRS can be appointed as a VLW. Now the post of the VLW has been abolished. In that place, it has become the Panchayat Executive Officer.
Yes,
Your first blush, you just wanted to impress this court that since the VLW post virtually has redesignated or the nomenclature has been staged to the Panchayat Executive Officer. So why their opportunity should be carved?
Lord, sir, that has been, Lord, sir, clarified that under Annex 8 with regard to the Kendrapada, Lord, District Kendrapada. That you, Lordship, kindly see my rejoinder. Paragraph, my lords. Paragraph 18. Paragraph 8, my lords.
You rejoinder?
Para 8, page 126 of the running brief.
That it is respectfully submitted?
That even after the introduction of new amendment rule 2021, the district Panchayat officer Mayurbhanj prepared the provision gradation list of GRS of Mayurbhanj district in 2021 and completed the procedure for giving promotion to GRS to the post of PO. But all of a sudden, same was not implemented for the reasons best known to them. It is respectfully submitted the law enacted by the state is applicable to all state machineries, but the collector and district magistrate Kendrapada on 17/8/2021 has given promotion GRS to the post of PO even after new amendment came into force. The OP number 1, being the commissioner of PR department, is supposed to well aware of the status of its department in all the districts under the state and should have filed affidavit very carefully. But OP number 1 has filed affidavit casually without verifying the status of its own department. So its action is contemptuous in this on this score. Reprisal is liable to be allowed. The petitioner therefore enclosing copy of gradation list dated 27/8/2021 prepared by DPO Mayurbhanj and Office of the Collector.
Gradation list is not a very relevant document in the present controversy.
Hello.
Gradation list always updated whenever it is required. So that will be there. For purpose of creation of the zone of consideration, having regard to the maximum age, the zone will be considered on the basis of the gradation list. So that the junior people doesn't still march over the senior people. So this is not the issue. Issue is that after the enactment, the new rule came into force, whether any appointing authority can appoint someone from GRS to the Panchayat Executive.
They have done it under Annex 8.
No, that is why immediately when you submitted, I asked the Advocate General appearing. But my second question still remains unanswered.
Lord, so they have created.
No, if it fails the test of legality, they said order, and there can be certain circumstances that order has been passed. Maybe order was approved before the rules came into state on file. So the authority thought that we should issue it because it is already approved before the new rules came into existence in file, not in the public domain. So it came up in the public domain after the rules were published. So that may create a confusion, and the Advocate General will apprise that about this, what exactly happened, the factual aspect. Even if, considering that has happened, whether after a new rule came, a new consideration can be made on the basis of the old rules. That question we have to answer before, if you want to invoke the equality clause to show there was an discrimination.
My lords, I do invoke that clause, and I also.
No, that this is not a negative concept. It is a positive concept.
No, this is a positive because as I had.
No, that just hear me carefully and then reply. First of all, on the basis of any error, you cannot claim equality. Error is an error. On the basis of an illegal order, maybe it was not disturbed by any court, you cannot claim the benefit under Article 14. On the basis of an order which did not take the law in proper consideration, The court has reached to a different conclusion that this should be the proper interpretation of the law. In that event also, you cannot get the benefit under Article 14. So you have to overcome these hurdles. Equality clause is a positive concept. Discrimination must be on the face. That in violation of the law, in violation of the fairness, then of course the Article 14 can be applied.
Millers, they have created the post, my lord. Not that as your lordship suggested for 2
No, that this amendment in para 6 you have shown to us.
My lords. Oh bless. Grateful.
It's all right.
Lords, retrospectivity of that application that has also Miller's.
And that is the reason that day this Justice Raju's judgment he has referred.
Look, they are also.
No, they're clear. Supreme Court has clearly laid down. There are subsequent decisions also of the Supreme Court that it is no more a good law. Earlier it was a law by the Supreme Court that if the vacancies are created under the old rules, those vacancies shall be filled under the provisions of the old rules. Supreme Court said no, sorry. From 2003 started changing, and 2014 there is a completely say that will be only considered under the new rule, and that demolishes your entire argument.
No, sir. One aspect that para 8.3 of that judgment, that is state of Himachal Pradesh and others versus Rajkumar, that this aspect has been dealt with. And the last 2-3 lines I want.
Para 10.
Para 82.3. 82.3.
2003 judgment you are referring.
Lord, so that is the state of Himachal Pradesh and others versus Rajkumar and others.
It is
2023.
23 judgment.
There are last 2 to
But
3.
more explicit law you will get in 2003 judgment. And another judgment has not been referred. This is the state of Tripura versus some Chakraborty. Huh?
Nikhil Ranjan Chakraborty. Nikhil Ranjan Chakraborty.
Right. They are also the same principle as declared by this. Do you have the judgment?
Yes, sir.
Lords, their lordship, lords, what I persuade lordship, try to persuade lordship. The only requirement is that lordship, lords, entire paragraph I am just beginning. The government is entitled to take conscious policy decision not to fill up the vacancies arising prior to the amendment of rules. The employees does not acquire any vested right to being considered for promotion in accordance with the repealed rules in view of the policy decision taken by the government. There is no obligation for the government to make appointment as per the old rules in the event of restructuring of the cadre in the intended for efficient working of the unit. The only requirement is that policy decision of the government must be fair and reasonable and must be justified on the touchstone of Article 14 that they have stated.
That's right. I am also showing certain things that you have to overcome. Otherwise, Article 14 cannot be invoked by the court. All right. Thank you for completing within time.
Lordship, perhaps, no. Unfortunately, answer because you have raised a point.
No. It is not an answer. You will just inquire from the authorities.
In fact, Lordship, kindly consider 2 aspects, Lordship. In this writ application, there are 2 aspects. One, Lordship, we have challenged the validity of these rules. That your Lordship will tell you the entire judgment. The second part is, Lordship, so far the leftovers Gram Raj Sevaks, the working under Gram Panchayat.
Mr. Mohanty has submitted that the entire 122 has been declared inoperative by this court. Do you just subscribe to this opinion? Or only the subsection 3 was struck down? What is the crux of that judgment?
Lordship, in fact, Lordship, Lordship, what I was reading out, Lordship, entire section has been struck down, Lordship. Just again, I'm reading that last concluded part.
Please do not read the part of the submission made by the learned counsel. But the law has been laid down, read only that.
No, only they have struck down 122.3, Lordship.
Exactly so.
123 struck down. But Lordship, it is the entire amendment is a concerns with the Lordship's judgment. Your Lordship is categorized, opined in the judgment, Lordship, because there should be no interference by the bureaucrats. That's why they ought to have been struck down the entire provision. But Lordship kindly cancel Lordship kindly the amendment. What they have done, the mischief they have done.
Yesterday I have made sufficient observation on that aspect.
No, Lordship. The amendment, in fact, pursuant to Lordship's direction, they come up with the amendment to the 4. And it was rectified in 2011, it was amended.
Just try to understand.
No, they have incorporated the collector position in 2016. Lordship, the mischief part they have done, they have not amended the law as per Lordship's judgment. They amended. And subsequently, when they feel that they are feeling unsafe because our power is going away, then Lordship in 2016 they come up with this amendment that they have incorporated the clause, the collector has the power.
Right. Up to this level, we have no difficulty. Difficulty starts when that provisions were challenged before the court.
In fact, Lordship, yesterday,
Mr. Doloi, that I appreciate and I honor your emotion, but we cannot allow emotion to take over the reasons that you have challenged this entire section of 122 by writ petition, including all the 3 subsections. Court filtered all your objections,
Lordship,
and thereafter says only we are striking down the subsection 3, not subsection 1 and 2. And we have shown you 1 categorically provides the government the power to appoint the Panchayat executive officer.
But Lordship, this collector position, they incorporated in the 2016, not in 2011.
No, it's all right.
No, so Lordship, this subsequent amendment. So it is never under challenge. Now, Lordship.
You have also no challenge.
Now they are coming, Lordship. Now the
Panchayats
are coming. Lordship, they are coming. I'm not on that, Lordship. In fact, Lordship, I'm not on that.
At least in these 2 writ petitions, there is no challenge.
No, exactly, Lordship. There is no challenge. But Lordship, my humble submission, because now Lordship can consider our position. Because here the Panchayat is not the petitioner or any Sarpanch is the petitioner. Here all the Gram Raj Sevaks are petitioner, Lordship. Here we are claiming our claims on 2 folds, Lordship. Once we are saying, please allow to participate in the subsequent rules because you have fixed a upper age limit that is 45. For that reason, you are devouring most of the applicants because we are working since 2006, Lordship. And now it is 2023. By this time, most of the Gram Raj Sevaks have crossed their age limit, the 45. And second, Lordship, I can demonstrate what they are saying. They are saying, Lordship, that they are putting a very unreasonable clause that their career will be assessment by the collector and the collector will produce a continuity certificate. The entire crux of the challenge before coming challenging the entire rules. This is the only point. They have fixed a one criteria.
Just try to understand that. Try to understand that.
Lordship.
If the rules are not declared unconstitutional,
Lordship.
right?
Lordship.
Certificate has no consequence, right? Secondly, when the project, the MGN Rega was visualized,
Lordship,
the collectors was the controlling authority. They are controlling the entire project. They are the implementing officer.
No, what they have done, Lordship?
No. Later on, what has happened? Central government by UFA subsequent notification says their services will be controlled by the panchayats.
Lordship.
Gram Panchayat.
In fact, Lordship, perhaps I am unable to convince Lordship. Initially, they have made the law that the Gram Panchayat is the controlling authority. So, Lordship, the agreement was made with the Gram Panchayat since 2006. In 2018, they have come up with a notification. No Gram collector is the controlling authority. So, since 2018, there is no agreement with any of the collectors, Lordship. Look at my statement and Advocate General also make a statement also, your Lordship.
No. Your objection so far from the submission you made in the yesterday that I was understand that since the collector is the appointing authority of the Panchayat executive officer, through the Panchayat executive officer, the state will control the autonomy of the all right.
But that is the Lordship, that was the judgment, Lordship, at the relevant time, where challenged on 13 notification, where they made 70-30%.
Oh, that earlier judgment.
Lordship, earlier judgment, Lordship. So, Lordship, kindly consider our position. By this judgment, Lordship, they will get the hand to eliminate all the Gram Raj Lordship. I will demonstrate, Lordship. I can demonstrate now also in my pleadings, Lordship, and my papers. They will not allow a single Gram Raj Sevak to get the promotion. If I will be counsel for a petitioner for the private persons, Lordship, do the freshers, I can argue, Lordship, no GRS can be allowed to participate in the proceeding, Lordship. Lordship, kindly.
No, they have to taken a definite step. They will not be allowed. Because they have to thrown out of the zone of consideration.
No, Lordship, they have considered us, Lordship. Lordship,
no, that we have seen.
Lordship, they have considered, but they are putting such an unreasonable clause. That clause will divide the entire 6,000 Gram Raj Sevaks from the state. They can't participate in the proceeding, in the selection procedure, Lordship. Restricting all, not only age, because they have put such a condition. So, Lordship, that is my humble submission before Lordship. Like consider, Lordship, that aspect. only to give livelihood to lordship to all these Gram Sevaks. We have worked since 2006.
Yes.
The validity can be tested by different case lordship, but so far our plight is concerned, because lordship kindly consider it is a very sensitive issue lordship for the state lordship, because all the Gram Panchayats will be affected.
The entire livelihood will be at stake, lords. They are having family background, lords. They have undertaken the livelihood on this assurance by the state that they will continue. The power vested with the Gram Panchayat and the lords collector or executive officer has no place, lords, with regard to Gram Panchayat. They are
No, wait, this is the.
Rules lordship,
Annexure 18, no, subsequent this order of appointment.
Appointment lordship, yes, lordship.
Annexure 18.
18, lordship. 18.
This is 151 page number?
Yes.
All right, we for this for two writ petitions arguments are complete.
Lordship, page 97 with a great lordship.
In your writ petition or Mr.
No. My petition, page 97, lordship. Page 97. What is lordship? Compelling. Why you have compelled? Because these persons have challenged the validity.
We have understood that point.
No, lordship, kindly see what they have given the chance, but how you can participate? And those who are continuing lordship, not a single GRS have the continued certificate lordship, because they have made the confusing the law. But initially it was under the Gram Panchayat and a 1-year contract, and every year has to be agreement has to be executed with the Gram Panchayat. Now they the change law with the collector, and no collector has made any agreement with the Gram Service lordship. Let them make a statement. The collectors have come up with an agreement. They have done an agreement. So no continued certificate will be available for any GRS in the state lordship.
Panchayat is making agreement.
Up to 2018, Panchayat are doing. And that is never continued lordship, because there is a gap, definitely, because their performance will be assessed. They are then also they are authorizing to come up for a second year agreement. So this clause 2 lordship is unreasonable. It has to be considered. At least take to consider this aspect lordship. Otherwise, nobody can participate lordship. And looking into the decision of this Kendrapada collector lordship, because after the upcoming of these rules, they have given promotion. So that's why all the matters not be pending for honorable single judge. They have also given granted interim order, because we were considered the sum of the district. Why not to others lordship? That's why all the matters pending before honorable single judge stage continuing lordship. My humble submission lordship.
No, whether that was also our query, that whether the new rules
lordship
have been stayed.
Not rules, our post has been reserved lordship, because in 2013 rules, they have kept 30% reserved for the Gram Sevaks.
No,
we are claiming that post. That post has been stayed by honorable single judge. Lordship has given that protection. Honorable single judge also given that protection. That post may be kept reserved for this Gram Sevaks. That is kept reserved lordship by interference of honorable single judges. Lordship is given protection to the entire state, but so far the individual district is concerned, coordinated benches as a single judge has given protection to all district lordship.
Almost all districts.
Writ petition filed by you, it has been stated as subject to result of the writ petition.
That is, in this case, Lordship, division bench matter, but single bench,
No, single bench.
that may be one case, Lordship.
Annexure 6A.
Maybe one case, Lordship, but those are.
Just can you supply us these interim orders?
Lordship, I will supply, Lordship. I'll supply all interim orders, Lordship.
All right.
Your Lordship may take note of one judgment. 2019, I'll give the judgments. 2019, volume 19, SCC 626.
2019?
Volume 19. I'm giving the citation.
All right.
Your Lordship may only see paragraph 39 to 48 on negative equality, which fell from your Lordship's minutes, where they have discussed several judgments to say that even if some order has been passed illegally, wrongfully, then negative equality is not available under Article 40.
Yes.
If your Lordship may see paragraph 656, at para 39 at page 656. I will just read 4 lines and then I will sit down. My Lord Savitri. This is a case which went from Odisha also. Para 39.
Yes.
It was lastly submitted that concerning other persons' orders have been passed by tribunal, which has been affirmed by the High Court, and grant in aid has been released under 1994 order. As such, on ground of parity, this is what my learned friends are saying, this court should not interfere. No doubt there had been a divergence of opinion on the aforesaid issue. Be that as it may, in our opinion, there is no concept of negative equality under Article 14 of the Constitution. In case the person has a right, he has to be treated equally. Where a right is not available, a person cannot claim rights to be treated equally, as that right does not exist. Negative equality, when the right does not exist, cannot be claimed. And then they rely on Basavraj LAO and large number of judgments, Chamanlal versus State of Punjab.
Now, that is what I have pointed out already.
Lordship is right. So that's the law.
But we are not claiming the law of
just
parity.
1 minute.
Sorry. Extremely sorry.
So therefore, while I will reply to your Lordship what is 17.8, but still this is the law.
But Lordship,
Only thing that
we are not claiming the law of parity, Lordship.
That one question may not be strictly legal.
Lordship is.
That what is the reason behind? All
How
of a
this
sudden, these
person
poor
got it?
people, some right, limited right
Correct,
they created, you have taken away. What is the reason behind that?
My Lord, which one?
You are a welfare state.
Yes.
We want to see your human face.
Correct.
This is not a human
Right.
face.
No, my Lord, I'll check out why these persons got it. But that rule has been challenged by them on some other ground. Now they are saying something else. So your Lordships are saying that why did we fix a time limit, age limit for that, right?
No, that is leave that apart.
Yes.
This 30% posts were created for them because you know the large number of GRS are working for more than 20 years to 25 years.
Only if, my Lord, only if posts were vacant. They didn't have a right under that. Kindly see that old rule.
No, that is why I'm
Yes.
telling you.
So only if vacancies are there.
It is a source of a solace only.
Correct.
There is no definite cause they will get the appointment. They want to be considered.
Yes.
That much, and you have taken that also. Apart from all the tools of the applications of Article 14 or the rules,
Policy decision, etc.
what is the reason behind? And all of a sudden, why you have become so just stiff that I will not consider these people?
We are giving an equal chance to everybody. So in this process, now what happens is everybody gets a chance, they also get a chance.
No, that's all right.
Yes.
But
While we were
the state has always with the power to create a special law for the special category of people.
Therefore, my Lord,
they are the special category of
my Lord,
people.
so these are posts. Let's look at it from another point of view.
Yes.
My Lord, there is a posts are vacant. Now it is open for everybody to participate.
Right. On that
Whoever
point, there is no debate.
And for this category of people, we have given them some weightage.
Some, yes, that if you are below 45 years, you can participate in the
15 marks for each year of
1 year, 15
1 year,
marks,
15
maximum
marks.
15 marks they can carry.
So they start with the 15 mark plus.
Yes.
And your Lordship,
But that should be the continuous service.
Continuous service.
Yes.
So suppose somebody has done 8 years, 10 years, he gets for one completed year of service, he gets 1 mark. So therefore here, if he is good, he'll compete with others and get. Otherwise,
Their main grievance is that what we have taken that 30%.
There was another category of people who had not been able to be considered at all.
No, we are just let us this discussion we can confine to this GRS only.
Correct.
They are before us.
My lord, the GRS are in any way getting considered now, except probably people who are above 45.
They will not be considered.
They are not considered, but rest of them are considered with a weightage. What was the earlier rule? Let us see the earlier rule, if your lordship don't mind. The earlier rule said.
Earlier rule, weightage was not there.
Earlier rule said only if there is a vacancy, then 70% by direct recruit, 30% from them.
From them.
If there was no vacancy, nothing. So
Right.
now, from nothing, they come to a 100% category where they can participate with everybody else, get a weightage, get an age preference. So therefore, it's a level playing field for everyone, including them. Suppose I appear and I have never worked, then I start from 0, they start from 15. So he gets a head start of 15 marks in the examination.
All right. And consider also the candidates who are directly participating.
Yes, madam.
Their age and energy versus they have put the continuous service and their mental frame and their aptitude at that age.
No, I
These are to be
understand what your
balanced.
lordships are saying.
These are to be balanced sometime. All right. You just give this clarification why after the rule was introduced,
Yes.
this promotion order has been passed.
Right. I will do that. Right. Deeply obliged.
Grateful.
And if you want to give any written note of
Written, lots-
submission
lots.
by tomorrow.
By tomorrow, let's say tomorrow is working day. Lordship said this week. By this week, Lordship. But tomorrow is working day, Lordship. Again.
Then we have to fix a date on next day
Lordship,
to
Lordship.
filing the written note of
Lordship,
submission.
Grateful, Lordship.
Tuesday. The hearing is complete. As the counsel for the petitioners has proposed to file written note of submission. Let the matter be listed on Tuesday. Only for purpose of acceptance of written note.
My lord, if I am not there on the next date, my learned friend.
All it. Sure.
Deep blue.
So other matters, date will be given.
Lordship.
This is keep with this file. Please, written note should be very small, not big.
4 or 5 pages.
Because I am now struggling with one written note that is triple the entire writ petition.